This recording is an offering of Networks for Training and Development's online university.
Hi everyone, this is Rosa McAllister. Today we're going to be talking about assistive technology and special ed law, particularly here in Pennsylvania. And I'm very pleased that we have with us a guest speaker, Judith Gran from PILCOP, the Public Interest Law Center of Philadelphia. She is a very wonderful, dynamic speaker, presenter, and certainly extremely knowledgeable, and has lots of insider information about just this very issue. So I'm going to pass this to Judy.
Thank you, Rosa. We're going to be talking about assistive technology and the law with an emphasis on Pennsylvania, but not exclusively Pennsylvania. And I think you'll find that the law is really quite a powerful tool for getting assistive technology services for students with disabilities who need them. I'm going to talk first about the IDEA regulations, just to get the basic framework of what the law requires, and then give a brief overview of what schools need to do to enable students with disabilities to benefit from assistive technology, and then look a bit at the case law. First, we're going to talk about the IDEA regulations on assistive technology. As those of you know who have read the statute and the regulations, they're very complex and very dense. But hopefully this format will enable you to go back and look at the text when you need to.
Yeah, there we go.
IDEA defines an assistive technology device as any item, piece of equipment, or product system, whether acquired commercially off the shelf, modified, or customized, that is used to increase, maintain, or improve the functional capabilities of a child with a disability. And that's the very broad definition that you've seen in other statutes. It's pretty universal across the board in federal law. However, this last time around, the regulations were amended to include the provision that the term does not include a medical device that is surgically implanted or the replacement of such a device. And that was meant primarily to exclude services to students with cochlear implants, specifically mapping of those devices, although the commentary on the reg says that school staff can check on the devices if they want to. They don't have to really do anything to maintain them. And there's been a lot of controversy about that particular addition to IDEA this time around, because it really isn't so clear in the statute that Congress meant to exclude it. But it did get into the regulations, and so far that interpretation of the statute has been upheld by the courts. Just as important as assistive technology device is assistive technology service, which is defined as any service that directly assists a child with a disability in the selection, acquisition, or use of an assistive technology device. And this can include evaluation of the needs of a child with a disability, including a functional evaluation of the child in the child's customary environment. It can include purchasing, leasing, or otherwise providing for the acquisition of assistive technology devices. It can include selecting, designing, fitting, customizing, adapting, applying, maintaining, repairing, or replacing assistive technology devices. And very important, coordinating and using other therapies, interventions, or services with assistive technology devices, such as those associated with existing education and rehabilitation plans and programs. And perhaps most important of all, training or technical assistance for a child with a disability, or if appropriate, that child's family, and training and technical assistance for professionals, including educators, therapists, everyone in the school environment, employers for students who are transitioning, and anyone else who provides services to or are substantially involved in the life of a child. And those are the pieces of the assistive technology requirement that are probably most difficult for school districts to get together. It's a lot easier to physically get a device, but getting everyone who will be using it with the child trained and coordinated and get all of those pieces working together, that's the really hard part. Under IDEA, assistive technology may be required under several different provisions of the law. It may be required as specially designed instruction, or it may be considered a related service, or it may be a supplementary aid or service. And all of those things are requirements that have to be stated in the IEP. And once they're in the IEP, of course, they must be delivered. Under IDEA, each local school district, intermediate unit, other public agency must ensure that assistive technology devices and services, or both, are made available to a child with a disability if required as part of the child's special education, related services, or supplementary aids and services. And supplementary aids and services is defined in the law as aids, services, and other supports that are provided in regular education classes, other education-related settings, and in extracurricular and non-academic settings to enable children with disabilities to be educated with non-disabled children to the maximum extent appropriate. That addition of extracurricular and non-academic settings is new in the most recent regulations under IDEA that were promulgated in 2006. They became effective this last school year. So that is another piece of the educational experience that traditionally has been relatively untouched by supplementary aids and services. It's been a lot harder to organize and deliver services in non-academic settings than in the classroom. The basic requirement governing assistive technology in the IEP, whichever rubric it may come into the IEP under, is that if the IEP team determines that the student needs assistive technology, it has to provide it. And the IEP team must consider whether a student with disabilities needs assistive technology devices and services. So it's not something the IEP team really has discretion to consider or not to consider. And I think you'll see when we get to the case law that what has driven the results in a lot of the cases is this duty to identify the child's needs for assistive technology and meet them in the IEP. Another useful requirement in the regulations is that students may take their devices home. On a case-by-case basis, the use of school-purchased assistive technology devices may be taken home. If the child's IEP team determines that the child needs access to those devices in order to receive FAPE. And I think fairly overwhelmingly, when those cases have gone to the dispute resolution process, the resolution has been that the child should be able to take the devices home. Even though schools are sometimes a little reluctant to do that, I think generally it's true more often than not that if a child needs a device in school, he's going to need it at home as well. I'm sorry. I referred to the acronym FAPE. It stands for Free Appropriate Public Education. That's the basic requirement under IDEA that all students with disabilities must receive. And when we get to the case law, we'll see a little bit about how that works out in real-life situations. Under IDEA, it's very clear in the regs that assistive technology is not just for special education teachers. A regular education teacher of a child with a disability must, to the extent appropriate, participate in the development of the IEP for the child, including the determination of the supplementary aids and services, program modifications, and supports for school personnel. And all of that could take the form of assistive technology devices and services. Under IDEA, as it was amended most recently in 2004, the state may, but it doesn't have to, reserve some of its Part B allocation. This is the money that Congress gives the states every year to pay for some part of the services that students between the ages of 3 and 21 receive. And they can set aside some of that funding to pay for support, direct services, technical assistance, personnel preparation, and professional development and training. And that can be used to improve the use of technology in the classroom. For children with disabilities, it can be used to support the use of technology, including technology with universal design principles and assistive technology devices to maximize accessibility to the general education curriculum. And the wording of the statute or the regulation makes clear that the state can do that, but it doesn't have to. So this is a really good area for people to advocate with their state educational agency for attention to assistive technology. What schools need to do to enable students with disabilities to benefit from assistive technology? Well, they need to address the costs and benefits of assistive technology. And the benefits, of course, are very real. So that's very important, not just to look at it as something that is costly and expensive, as so often is the case, but the real world benefits for children with disabilities. School staff need to stay up to date on what's available in assistive technology. And again, that can be quite difficult because there are very few specialists in assistive technology in schools. Most often, they are located in the intermediate units, which, because they're a separate agency and not part of the school district, they report to a different chain of command. There's some real obvious coordination issues that occur that can be very difficult to resolve, not through anyone's fault, but just because that's the way things are organized. School staff need to acquire experience and expertise. I think it can't just be consigned to technical assistance and consultation staff in the intermediate units or in Patton. I think that expertise really needs to be developed in-house. It's very important to make time for training. That can be very, very difficult to coordinate and schedule. And for teachers, it is most useful to have that be on-site in the building, in the classroom, which again can be quite difficult for some of the outside training and technical assistance people who don't work in the school district to accommodate. So those are some of the, really, I think, big barriers to getting adequate assistive technology in schools. And administrators really need to support the use of assistive technology in the schools. One of the problems, I think, is that the people in the school building who have their hands on the technology are not necessarily special educators and therapists. And when a student with disabilities is involved, the natural tendency of the school administration is to see that as a responsibility of special education. And when we get to some of the cases, we'll see what some of those barriers can be in real life, because the speech therapist or the special education director doesn't necessarily have the ability to get a piece of software installed on a computer in the classroom. So the principal of the building really needs to be behind the delivery of assistive technology in the classroom. Now we're going to talk about some cases. Most of these cases have come up through the Pennsylvania dispute resolution system. And that is, as most of you probably know, that's the system in which you get a due process hearing, and then perhaps an appeal, and then perhaps a case in court. When a parent disagrees with an IEP, the parent can request mediation, a pre-hearing conference, or a due process hearing. If the parent requests a due process hearing, she has to submit a complaint to the Office for Dispute Resolution, which is the coordinating body that arranges the due process hearings, and then have a due process hearing before a hearing officer. And along the way, hopefully, a meeting with the school district, which is now mandatory, to try to resolve the issues without getting to a hearing. After the hearing is over and the hearing officer has rendered a decision, either party can appeal to the Special Education Appeals Panel, and that's a panel of 3 members, and there are about 16 members overall, but they're kind of mixed and matched and shuffled. And they make a decision, but they don't hear new evidence. There's no new hearing. It's just a review of the administrative record. And then, if either party is dissatisfied with that result, they can file a civil action in federal court or a petition for review in the Commonwealth Court. And historically, parents in Pennsylvania have gone to federal court, and school districts have gone to Commonwealth Court. Federal judges in this jurisdiction are quite receptive to receiving additional evidence about what's happened since the hearing, so that's another benefit of going to federal court from the parent's perspective. The typical remedies in a due process hearing or case under IDEA include an order to provide more appropriate services or a more appropriate placement. They can include an order to provide compensatory education. That's a very, very common remedy all over the country, but particularly in Pennsylvania. And compensatory education just means that the student is entitled to receive the equivalent of the services he didn't receive. And sometimes that's calculated on an hour-by-hour basis or a day-by-day basis. Sometimes it's calculated as kind of an equitable percentage. If you figure, for example, that assistive technology was worth about 20% of the student's overall education experience and he wasn't getting it, then you might award the student 20% of the school year or whatever time period he didn't receive that service. It can also take the form of services purchased by the parent out of a fund that is held by the district or held in a trust that the parent can then access. And not only do many parents prefer that latter alternative, but I think many school districts prefer it as well, because it's really up to the parent under that scenario to choose the services, arrange for them to be delivered, and pay for them. And if the district was having difficulty providing the services in the first place, that really makes sense from the district's perspective as well. Another remedy that's very common is tuition reimbursement. If the student is not getting an appropriate education in the regular public school, the parent can give the school district notice that it's going to purchase the services elsewhere, and that could be either in a school, sending the student to a whole different private school, or it could mean just purchasing assistive technology or other services privately. And a final remedy is damages, which cannot be ordered by a hearing officer or the appeals panel. It can only be ordered by a court. Some of the principles I think we see from the case law are, first, failure to evaluate a student's need for assistive technology may represent a denial of the right to a free, appropriate public education. Just that failure to evaluate. And students have received compensatory education for that failure. Second, failure to incorporate recommended assistive technology in the student's IEP may represent a denial of the right to a free, appropriate public education. So districts need to be very careful when they get an evaluation with a lot of assistive technology recommended in it, and they don't have an evaluation of their own that says it's not needed. That evaluation and those recommendations may really create a situation in which the district will be ordered to provide what was recommended. Another principle is that the school district may not limit the use of assistive technology to the classroom. They can't have a general policy that they will not allow the student to take the device outside the classroom or take it home. And finally, that assistive technology may prevent unnecessarily restrictive placements.
A question. Judy, do you think that this is part of the reason why schools seem oftentimes very hesitant to even seek an evaluation for assistive technology for a child?
Yes, I do. And I think most school districts here in Pennsylvania that I have encountered use the SET process, which is not really an evaluation. It's an action planning process, and it's not done by the IEP team. It's done by some other group of people within the school. And it may result in the acquisition of appropriate devices, and it may result in good services, but that accountability to the IEP team process is really what's missing in that process, and I think that's why districts are reluctant to formally refer the student for assistive technology evaluations. First, I'd like to talk about some cases about evaluations. Well, the first case is a very simple one. Christopher was a student who had difficulty with written language and paper and pencil tasks, and the case went to a hearing over the issue of whether the district should have evaluated his need for assistive technology. And the hearing officer and appeals panel said yes, his needs were quite obvious, and awarded 270 hours of compensatory education just for the failure to consider his assistive technology needs.
I think.
And as a result, in addition to the compensatory education, the district was ordered to provide a computer for Christopher's use until he graduated or ceased to reside in the district. But they did not have to give him a computer and voice-to-text software that he would personally own. And that's another, I guess I should have identified that as a principle. That is the limit of the district's responsibility. They don't have a responsibility to actually buy a device for the student to have and keep. Another evaluation case concerned Jenna, who was deaf and moved to Pennsylvania from another state, and she had received assistive technology there. And after she moved to the district just didn't bother to reevaluate her, but just reviewed the paperwork and concluded that she really didn't need assistive technology services. And the hearing officer ruled that the district had violated Jenna's right to a free, appropriate public education by just concluding that she didn't need assistive technology. They should have evaluated her first. Very interesting case involved a student named Caitlin who had spinal muscular atrophy, and the school district again failed to conduct an assistive technology evaluation. And the hearing officer ordered a comprehensive evaluation that must make specific recommendations about equipment, materials, and software. So that was really a powerful result. And it didn't end there, because the hearing officer also ordered the district to actually provide the assistive technology that Caitlin needed, and said this could include a computer, printer, modem, internet access, and software for her use at home, as well as training for Caitlin, her parent, and the district staff. And the school district had to provide 450 school days of compensatory education for the failure to evaluate Caitlin. Bearing in mind that a year is 180 days, that's really a lot of compensatory education. Gregory's case was about a middle school student whose parent had specifically requested an assistive technology evaluation and never got it. The school district conducted a record review and referred Gregory for the SET process. And a team of teachers and administrators, not the IEP team, met and decided to try out a laptop and Kurzweil software, which is
we haven't explored it yet specifically, but I think some groups will be. We're going to be talking about it a little bit more, but it's a very powerful piece of instructional technology, actually, that can do many, many things to assist students. It can do voice to text, text to voice, and do a number of other things.
Well, Gregory had a severe reading disability. He was a very bright student who had dyslexia, and so he was using it for text to voice output primarily to read. And he used the laptop for 30 days, and the district decided to return it. I think they said he was pushing the CD player in and out.
I'm covering my head.
He was 13. And he was only allowed to use the Kurzweil software in the special education resource room, where he was for about an hour a day. And the staff were supposed to collect data on what he did with the Kurzweil device, but they really didn't. They just took a few notes here and there. So his case went to a hearing, and one of the big issues was the adequacy of the district's evaluation process. And the hearing officer held that the SET process was adequate, that was okay, but the appeals panel reversed and held that if you just apply the regulations on what an evaluation is and what you need to look at in terms of assistive technology, the SET process really doesn't pass muster. So the appeals panel held that that the school district had never actually evaluated Greg's needs for assistive technology. The next group of cases is about failure to implement recommendations for assistive technology. Christie's case involved a student in high school whose district was ordered to conduct an independent evaluation for assistive technology. As you probably know, under IDEA, a parent can request an independent evaluation at public expense whenever she disagrees with the school district's evaluation. And the burden then passes to the district to prove that its own evaluation is appropriate, and it would have to do that in a due process hearing, or else it has to pay for the independent evaluation and let it go forward. And the district apparently didn't do the do the right thing with respect to that, so it was ordered to provide the independent evaluation. And that evaluation identified assistive technology needs. However, the district then went on to develop an IEP for Christy that had no assistive technology goals. And the hearing officer held that that IEP was inadequate because it did not address her identified needs for assistive technology. The next case, Corollas, involved a student who had reflex sympathetic dystrophy and regional pain syndrome. And her physician, because this is a medical condition, had suggested the use of a computer for note-taking and school writing assignments. And her parents asked for a laptop from the district, and the district didn't provide it, so they had a hearing. And after the hearing, she received an independent evaluation and compensatory education in the form of video, audio, and software programs. And that's kind of an interesting point, that compensatory education can take many forms. It is really up to the hearing officer to decide how to award it. After the hearing, after that order came down, the district provided a device called a Dream Writer and 2 instruction manuals, but they didn't provide anyone with any training. And her family was unable to figure out how to use the Dream Writer, and 10 months later took it back to the district without having used it. And then there were some other glitches along the way, which happen in school districts, such as the independent evaluation being delayed because the district assistive technology staff were not available for the IEP meeting. And another due process hearing took place after that, and the hearing officer ordered 2 hours a day of compensatory education as a remedy for the district's failure to implement the assistive technology recommendations in a timely manner, including, of course, the training recommendations. Hakeem, sorry, I gave him another name at some point. Hakeem had cerebral palsy and significant delays in language. And the issue in his case was whether a school district could limit the use of a laptop or other assistive technology device to the classroom, as the district wanted to do. The school district had made a laptop available, but only in the classroom. And after a due process hearing, the district was ordered to provide the laptop in and out of school to use at home and in the community. And the school district still refused to provide the laptop. And there had to be a second hearing and an appeal to the appeals panel to get them to actually do it. And the hearing officer found that this student would require special software and peripherals to derive even a minimal benefit from the use of a computer. So the district was ordered to provide a laptop, voice activation software, a printer, and a modem. The case of Alba, which was decided just recently by a federal court in New York, is a very moving and in some ways tragic case. Some of you may have heard of Alba about, 14 years ago, when President Clinton was at an open house at the White House. There was some sort of event at the White House, and Alba had a twin named Anastasia, and they were quite young at the time, still in elementary school, I think. And Anastasia came up to President Clinton and talked about her sister, who had severe disabilities, including quadriplegia, cerebral palsy, and she didn't speak. And she was placed in a different school building in segregated classrooms. And Anastasia asked President Clinton why her sister couldn't go to the same school that she did. And as a result, the president took a personal interest in Alba's situation and used his influence to enable her to go to school in her home school with her twin. And she did. The only problem was that she really wasn't provided services there. I'm not sure that the school district could have provided the services in any setting that she needed, but she was really kind of languishing in the classroom, and no one really was able to evaluate her because she didn't speak and she had so many motoric problems that all the testing that can be done that relies on either speech or motor control, just wasn't working with her. Finally, in 1993, this was shortly after President Clinton had met her, and Alba was 9 at the time, an assistive technology specialist named Dr. Blau evaluated Alba and found that she had an IQ of 132, but she was performing at a first grade level, and no assistive technology was being used. And her recommendations were presented to the Board of Education of the New York City schools, and they chose not to implement those recommendations. Alba was placed in regular class and provided a watered-down curriculum rather than the services recommended by Dr. Blau. That meant that the district simply simplified everything in the regular curriculum. They modified it, but she really didn't need a watered-down curriculum. She didn't need it to be simplified. She needed to be taught how to read, write, and use technology to be able to do those things. Finally, skipping forward to 2002, many years later, Alba graduated from high school, and her skills at that point were at a kindergarten to 4th grade level, depending on the subject. She had really not benefited as she should have from her education there. At that point, Dr. Blau came back into the picture and developed a program for Alba. And finally, the Department of Education agreed to implement the program at Queens College on the campus. And it was a pretty intensive program, but it had to be because Alba was really far behind. And it consisted of a full-time teacher, a full-time paraprofessional, transportation, and extensive use of computer technology, including a laptop loaded with specialized software and mounted on her wheelchair. And that was her primary communication device. And Alba benefited tremendously from this program. Her communication skills increased dramatically. She began to read books, communicate by email, initiate conversations, make phone calls. She began to live a pretty normal life. And she did so well, and she really seemed to be on the path to a career, that in 2006, her mother sought a 2-year extension of the program. And she sought that as compensatory education, as a remedy for the denial of an appropriate education that Alba had experienced from kindergarten through high school. And the case went to a hearing. The hearing officer and the review officer, in New York they have a 2-tier system similar to Pennsylvania's, but they ruled against Alba based on an agreement that her mother had signed earlier on when the New York City schools agreed to provide the services recommended by Dr. Blau at Queens College for an additional year. And the district had basically made Alba's mother sign away all rights to future services or to compensation. So the hearing officer denied relief based on that. And then the review officer said, well, he didn't know whether that was right, but it didn't matter because the statute of limitations, under IDEA, there's a 2-year limit on how far back you can go to raise claims about having been denied an appropriate education. So at that point, Alba's parent appealed to federal court, and the district court reversed everybody and said that the earlier agreement didn't bar compensatory education, and the statute of limitations didn't bar it either, and sent the case back to the administrative process. And although the court didn't go into the merits of the case in the decision, it sent some very strong signals to the school district and suggested that the Department of Education had failed to use methods and technologies that were known and available before 2002 when Alba graduated from high school. I think the suggestion was that the court wasn't saying that Alba had to use exactly the methods and devices and technologies that were recommended by Dr. Blau, the independent evaluator, but that it had to use something. And the court quoted Alba's special education teacher when she was in high school, who said basically, I taught Alba what I was given to teach her. I did what was available to me. I did what the school district does. And I think this failure of the district to search out a more appropriate approach to teaching Alba was really what swayed the district court, and felt that this was just such an outrageous dereliction that something had to be done. And I won't go into all the legal ins and outs of why the court didn't find the earlier agreement signing away the rights was enforceable, and why the statute of limitations didn't bar those claims, but the court had good legal reasons for finding that. And I'm sure we'll be hearing more about this case as it goes up to a higher court on appeal. This case was only decided last February. Assistive technology can also help students receive an education in regular class to the maximum extent appropriate. And one case along those lines was that of Jason, whose school district claimed that he could not be mainstreamed for math and social studies because of the tremendous quantity of reading and writing that was required in those classes. And Jason was a student with specific learning disabilities, and writing was difficult for him, and reading a lot of material was difficult for him. But the appeals panel wasn't at all impressed by that argument and held that the difficulties that Jason has in reading and writing are pretty common, and there are a lot of adaptations that are readily available to address those issues. And the panel, kind of on its own, suggested the district could use talking books, substitution of oral for written reports, and assistive technology. And the result was that the district was required to include Jason in all regular education courses. Finally, some cases about the failure to implement assistive technology services that the district has agreed to. David was a student with autism who communicated via text. That was really the first language that he learned when he was a very young child. And as he grew older, he learned to use a communication device called a chat PC, which uses symbols and contains many screens that a student can scroll through to communicate in rather complete thoughts. And David was coming back from the autistic support class in another school building to his neighborhood school, and nobody in the new school was trained in PECS or how to use this assistive technology device. but it was clear that he was supposed to be using it. It was in his IEP. The parents then purchased an upgrade to this device for use at home and programmed it themselves. And David took this back and forth to school for a while, and then the speech therapist took it upon herself to program David's own chat PC, and in the process erased its memory, lost everything, about 70, 80 hours of programming. Then the school district bought its own chat PC and programmed it differently from the family's device. So at that point, David stopped using either device because of the inconsistency. He needed, having autism, he needed a lot more consistency than having to figure out the programming every time he picked up the device. The teachers and therapists also didn't work with David on the chat PC. They weren't really teaching him how to use it. They said they made it available to him in class if he should choose to use it. In other words, they really didn't see their job as teaching him, as providing, in the language of the regs, assistive technology services. And we know that just giving someone a device is not enough. And this case went to a hearing, and the hearing officer awarded compensatory education. Finally, an interesting case involving a student with Down syndrome who is very capable in many ways, but his speech is very unclear. And he could do a lot with assistive technology, with software, if he had the right software. And his parent went out and obtained an independent assistive technology evaluation on his own. And the evaluation made many recommendations for specific software and recommended that the district assign a software manager to kind of coordinate the use of the software and getting it installed on computers in the district. And the district agreed to implement many of the recommendations. Unfortunately, it was kind of harder than anyone thought. I think this idea of a software manager sounded very logical and reasonable, but there was really no one in the district who had expertise in assistive technology. And so the district went to the intermediate unit to get training for the staff. And this was almost impossible to arrange because of everyone's schedule. And the consultant working for the intermediate unit with a lot of school districts to serve was very, very pressed for time. So that was very difficult to arrange. It took months to arrange. And then the school district assigned a speech therapist to serve as software manager. But the speech therapist was a contractor who worked for the district, didn't have any authority within the school building, and had little knowledge of assistive technology. And most of Raphael's classes were in regular education at that point, in the regular high school, and those teachers were not trained to use software. I'm not sure that others would have been trained, but in any event, those teachers had not had any kind of orientation in how to use the software that was recommended for him. And nobody really had any authority to install the software on computers in the classroom. There were many problems with the acquisition, installation, and maintenance of the software. The software manager kind of fell back on the notion that her job was making the software available to regular education teachers, and didn't train them and didn't train Raphael, the student, in how to use it. And the result was that many opportunities were missed for effective use of software. For example, Raphael was taking a regular education course in money management, and the staff, the teacher had decided, or I guess the teacher in collaboration with special education staff, had decided to teach him to write checks on oversized pieces of paper And he spent a whole semester writing numbers on these oversized pieces of paper. And I don't know, something about this just struck me as not very useful, mainly because I write about 2 checks a year, I guess. Mostly I buy.
Probably not that big.
No, mostly I buy things online and, pay the bills online, or they come out of my paycheck. And I think many of us are in that situation now. But even if someone concluded that it's really important for Raphael to learn to write checks, there's check writing software you can get for $29.95. And why not use all the technology that exists to teach Raphael how to actually use money, to use a credit card, to use to make online purchases, things that he could do very well, regardless of whatever fine motor and speech impairments he had. So the result of this situation was that the appeals panel found that Raphael had been denied a free appropriate public education for about 2 years and awarded compensatory education accordingly. And I think these cases illustrate that these assistive technology requirements really have a lot of teeth, a lot of bite when they're applied. The regs are very clear. Their application should be very clear. And I think the big challenge is bringing school districts to the point where they are able to deliver the services as required by the regs. And I think we all want them to do that, to come to that point, because you see these cases where kids are getting huge amounts of compensatory education awarded years after the fact. And that's not fair. It's really not fair to anyone, because compensatory education can never make up for what you've lost. You should have had it at the right time in your life when it could have made an even bigger difference. And it's kind of, in a way, not fair to school district staff to suddenly find out in a hearing that they've been doing the wrong thing. So I think there really is a huge need to educate school districts about their responsibilities under the law and to do what the judge said in Alba's case that they need to do. They need to seek out. They need to be curious. They need to want to know what is out there that can help this child receive a meaningful benefit from education. Thanks.
Thanks, Judy, so much. I know for many of you, you're in a position now where either you are a teacher or a teacher's aide, or are learning to be a teacher, or switching to be a teacher, or trying to figure out what your role in all of this is. And for many of you, you're probably wondering, so what does this mean for me, though? I'm a low guy on the totem pole. I can't do anything. And as we've been talking about in so many of our discussions online and in class and on Skype and everything else, what is our role in all of this? So I'm just going to ask Judy just another minute. Any thoughts on that, folks?
It really is hard when you're the low person on the totem pole, and when you don't control the resources and you don't make the decisions. But I think to surface these issues in whatever discussions you happen to be in with the school district, if you see that a student really needs assistive technology, I think it's something that anyone who has that observation needs to bring to the attention of the people in authority in the school district to be able to do something about that. And as I said, I think one of the strongest arguments in favor of that is what could be the consequences for the school district if it ignores a need that is fairly obvious. And I think I'm struck over and over again in the cases that the hearing officers in the courts are saying, this need was so apparent. How could anybody have ignored this. And yeah, people do because people tend to, if assistive technology is not being used a lot in that school district, it is easy to feel limited by what you have available. But that isn't the way a hearing officer or a court is likely to see it. They're likely to focus more on the student's needs and what could have been done. So I guess thinking yourself into that frame of reference and then talking about it to the people in authority. I know it is very difficult when you don't have authority, but I hope you all can try.
Thank you. And I think as we've been talking about this applies certainly in this discussion regarding students of all different ages who are connected in some way still with the educational system, but just as we've been talking about with our parents and grandparents and helping people become aware of what is out there, that maybe we don't know all the answers, but we know a little bit of information. We can push other people to find out more. We can all help one another to advocate, seek out, find out what is possible. And the reality is that in a lot of these situations that Judy talked about, as well as a lot of situations we all know, these are not huge pieces of equipment or huge adaptations, accommodations. Sometimes it's pretty simple stuff. Sometimes it includes some pretty detailed work, but a lot of times there's some simple adaptations. It's just a forethought, it's a concern, the idea of what can we do to try to help. And I think we all can do that. So thank you all. To end this discussion for now.
Thank you for listening. We hope the information provided was helpful. Don't forget to stop by our website and take advantage of all we have to offer. If you want to be kept informed of upcoming events, subscribe to our channel to be kept up to date on our future programs. Click on the link provided in the description if you wish to receive emails about our upcoming events and offerings.